Good evening, everyone. God, we got another full house. I don't know what we're doing, but welcome, everyone. Welcome to the Zoning Board's meeting of Thursday, January 22nd, 2026. Would you kindly make sure your phones are off, and can we stand for the pledge of allegiance?
I pledge allegiance to the flag
of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hey, Heather, you want to read this?
Sure. So just to read into the record, we did receive correspondence. One letter from Kim Judd regarding 1087 Old Country Road, a request to reopen appeal number 2025-042, and also a letter from Amy Loeb from PBMC Northville Health about 1087 Old Country Road, Riverhead, another request to reopen appeal number 2025-042. All right. I circulated it to the board. Okay, are we ready for public hearings? Okay, the first appeal number 2025-036, Mohammed Faisal, 2041 Osborn Avenue, Riverhead. The applicant requested their second adjournment, and they requested April 23rd of 2026.
Okay, can I have a motion?
So made.
Second?
Second.
All right, Mr. Barnes. Can you hear me, Leroy?
Aye.
Okay.
Yes, I can hear you.
Center?
Aye.
Zaweski?
Aye.
Phil?
Aye.
And I vote aye, so that adjournment has been moved to April 23rd, 2026. Go ahead.
And next, appeal number 2025-028, 505 Lincoln Street Opportunity Zone Fund, LLC. I believe the zoning board is looking to give this a lengthy adjournment. Anne Marie, is that correct?
That's correct. So the zoning board is going to seek to adjourn this matter until the parties, being the applicant, owner of the property, and adjacent owner, who appeared at the original zoning board meeting on this appeal, and thereafter expressed a desire and intention to resolve amongst themselves several issues that may resolve or eliminate all or part of the relief requested by the zoning board until June 11th to enable the parties to provide, demonstrate, and or detail the resolution of all or part of the issues raised between applicant and the owner versus the adjacent property owner.
So moved. Second.
Mr. Barnes?
Aye.
Aye.
Zaweski?
Aye.
Zillow?
Aye.
And I vote aye, so that's been adjourned. Thank you.
June 11th, 2026. Okay, and before we open appeal number 2025-043, does the applicant or the representative have the proof of mailings and affidavit of posting? Appeal number 2025-043, Breezy Hill Group 6 LLC, 1792 Middle Road, Calverton, Suffolk County Tax Map number 600-100-2-4.2, light industrial zoning for a special exception. Applicant requests a special exception pursuant to Town Code Chapter 301-222B, where the Zoning Board of Appeals may approve a special exception from one non-conforming use to another non-conforming use, to wit, applicant seeks to change from a non-conforming single-family residential use to a solid waste management facility, construction and demolition, debris processing, concrete and asphalt crushing and screening facility.
You're an attorney, right, sir?
Yes, sir.
All right, please state your name and address.
Yes, Stephen Lo Squadro, 649 Route 25A, Rocky Point, New York, on behalf of the applicant.
Okay, thank you.
And Mr. Chairman, members of the board, first of all, good evening. Happy New Year.
Good evening.
There are documents that I've set forth for all of you, one of which, the chairman, you have is tabbed and indicates a series of documents that will be relevant and will be referred to at different stages of the presentation.
Go right ahead.
Yes, sir. So, this is an application for a special exception. It's a form of an interpretation. It's brought pursuant to section 301-222B of the Town Code, providing that a non-conforming use on a lot may be changed to another non-conforming use when approved by special exception. Now, the lot in question had and has a non-conforming use on it, and that is a residential use. That use, the single-family residential home, exists on the site is reflected in documents that are attached to the application itself and are also contained in the documents provided to you. Now, for all of the board members, the particular documents that refer to the residential use are the last documents in the packet. And Mr. Chairman, those will be the documents that you have that are tabbed as Exhibit J. Now, the non-conforming use to which the applicant seeks a change is a concrete yard, a concrete crushing facility. And that has been the subject of a site plan that the applicant has had before the town for almost 10 years. You'll see from the first documents that are before you that site plan application was made in January of 2017. It was approved, the particular use that we're seeking here was actually approved by this board in 2018.
Just for clarification of the record, the zoning board determination in 2018 was a request for an interpretation. The interpretation by the zoning board was that it was not listed as a prohibited use under the then industrial A. The zoning board did not declare it a permitted use. They stated it was not listed as a prohibited use.
And Mr. Prudenti, of course, that's 100% correct. And as you know, that after that, because that was in February of 2018, the ZBA application was made. In April of 2018, the decision to which you're referring was issued. And then, of course, in August of 2018, and you'll see the correspondence attached from Ms. Thomas as attorney to the ZBA requested clarification, which the applicant provided. And that clarification, coupled with the interpretation to which you refer, allowed the site plan to move forward because it was a use that was not prohibited.
The only clarification legally that the zoning board could request was on an interpretation.
Correct.
And that's what they delivered.
That's true.
Interpretation.
Yes, and I'm just pointing out that there was a subsequent clarification sought, which was provided. And then, of course, the application continued from that time forward. Now, the concrete yard use, which is sought here, that would have been a conforming use provided prior to the town board's zone change, because as you may be aware, this was industrial A property. And then the town board, on its own motion, about 8 or so years into the application, as the applicant was on the cusp of approval, changed the zone and eliminated the use for which the applicant had applied back in 2017, and for which the applicant continued to apply after the ZBA interpretation. So the use then would be non-conforming, hence the application made under section 301-222B, which allows one non-conforming use to then be transferred to another non-conforming use. It's a mechanism that exists in the town code, particularly in a situation like this where a great inequity could occur, because you had an applicant here who has been in the process for almost 10 years, and then about 8 or so years, almost 9 years into the process, the zone was changed, stripping away a use for which the applicant was about to receive approval, as a final site plan had been submitted and SECRA had been essentially completed, and the applicant was just awaiting a final hearing for approval of its use. I will point out the following before I delve into some of the documents that I provided to you, to put this in some context and so you can have some more color on this and understand how this got to this point. First and foremost, under 301-222B, which allows one non-conforming use, if it exists, to have another non-conforming use established on the site. The non-conforming use, as I said, would be the concrete crushing facility, which would have, again, I repeat, have been conforming if the town board had not just had taken action on its own motion just before the applicant was about to receive final approval. But that use, we have to recognize, conforms entirely to the nature and character of what exists in the area. It conforms entirely to the nature and character of the uses that surround and are near the site. This is immediately adjacent to concrete crushing facilities. It directly neighbors the Suffolk concrete facility and other uses which are not just similar, but in many instances more intense or impactful than the use that the applicant seeks here, which again is the use for which the applicant applied, making a site plan application in 2017, and then continuing with the application as permitted by the planning board after appearing before the Board of Appeals. I've provided you with a series of documents. They establish how the applicant here has always acted in good faith, has always complied with every section of the town code application process, submitted a site plan application in January of 2017, together with a $25,000 fee, was told to make a ZBA application, submitted that in February of 2018. All of these documents are before you sequentially, chronologically. In March of 2018, the planning board issued a staff report permitting the application to move forward. In April of 2018, a decision was issued by this board which said this is not a prohibited use, as Ms. Prudenti noted. In August then of 2018, a clarification letter was requested by this board, to which the applicant responded. There's a copy of that provided to you as well. In March of 2019, there were additional site plan submissions requested by staff, planning staff on behalf of the planning board. Those were provided. In February of 2020, you'll see that there was a SECRA scoping notice issued. So the SECRA process here was very involved. The applicant spent hundreds of thousands of dollars on particular engineering, particularly from a SECRA perspective, to comply with the standards and analyses and testing and other processes required under the environmental impact statement process. All of that was done. Then, of course, unfortunately for the applicant, and many others for that matter, we have to be very mindful it was a difficult time, but the COVID pandemic hit, and the application, like many others, was slowed down for a bit. No fault of the applicant, no fault of the town. It was just difficult for business to be conducted in an expedited process at that time. You'll see, however, in January of 2023, there are documents before you that reflect that a final submission was made to the planning board. and it's marked final. And you'll see the letter from the engineers, Nelson and Pope, and I believe it's from one of the partners, Mr. Dixon, that reflects the fact that there were only 3 revisions that needed to be made at that time. And they were extremely minor, very ministerial in nature, adding a marking or a code to certain pages on the plan. Really scrivener's details at best. And then, of course, we know that what happened is there was a comprehensive plan that was in the works, and the town board changed the zone from industrial A to light industrial, which still allowed many industrial uses, but not the use for which the applicant had applied and on which the applicant had expended hundreds of thousands of dollars over essentially a 10-year period. So what was brought to the applicant's attention was that Section 301-222B is a mechanism by which a potentially inequitable situation can be remedied in a very narrow fashion. And that is what the request is here. The applicant does not seek anything more than what it applied for in 2017. It doesn't seek anything more than what it sought an interpretation on in 2018, and it certainly doesn't seek anything more than the clarification it provided at the board's request later on in 2018. Under the circumstances, the application is narrowly tailored. It's fair and reasonable. It would prevent a great inequity for someone who has been in a process for 10 years and had a change that was not requested and not sought, foisted upon the applicant. And it would allow a use, another non-conforming use, that is in complete character with everything that surrounds this use. Because the other uses are non-conforming as well, when we're talking about Suffolk Concrete and many others for that matter. Because the uses there, to a great extent, are much more impactful and intense than what the applicant proposes. And those uses were not established pursuant to a site plan that reflects current code standards. This would be. But certainly it is in harmony with what is found in that area, which is an area of industrial use. Clearly, the town had created zoning for that area in that way, so uses would be concentrated in certain areas, such as on Manor Road or on Cromer Avenue, for example. Uses are concentrated for those very purposes. So for all of those reasons, I respectfully submit on behalf of the applicant that the request is reasonable. It's very narrowly tailored. It prevents a great inequity that certainly everyone wants to avoid, given the actions taken when someone was on the cusp of approval, which has other implications and consequences that we're not going to discuss now, but certainly fair and reasonable and in harmony with what's found in the area. So for all of those reasons, again, members of the board and Mr. Chairman, I appreciate your time and your consideration. It seems like there are a fair amount of folks here, and to the extent that they are here for this and not for other matters that were adjourned, I'll be happy to listen to what they say, and if you deem it appropriate and I can answer questions that respond to what they say, I'll be very happy to do that.
To begin with, just for our benefit, for the benefit of yours, could you explain the operation? Suppose it was granted. Well, how would the operation work?
May I still call you Judge?
You call me anything you want. I've been called worse.
Well, I appreciate that, Judge. Judge, the use will not be different than uses that are found in the area. So, concrete is brought in.
By truck, I presume.
Yes. The applicant is a union road contractor. On road sites, concrete is often a byproduct of roads that are ground up or milled, as they say, or torn up, particularly from curbing It's brought to the site. The origin is always noted. The DEC requires that. It would not be from sites outside of Long Island, primarily in Suffolk County. The concrete is brought in, and it's crushed so it can be reused. One particular aspect, Judge, of this application, which would provide greater safeguards and control, as opposed to other facilities doing very similar things in the area, is that this would be established pursuant to current town code requirements. So you have Mr. Bergman and others from planning staff who ultimately, when the site plan is approved, attach a bunch of conditions which then get memorialized in covenants and restrictions that the applicant then has to file so that they run with the land and the site. That would be part of what would happen here as well.
Could you describe the crushing process, how it's done, what it's done with, et cetera? And I presume it's done outdoors?
It's done outdoors. There's a machine that crushes the concrete, and as I understand it, this is where maybe it goes a little bit beyond any expertise that I have, but what I've seen, because I did have the opportunity to observe it, there's water that's utilized both with the machine, but also in the surrounding site, because that prevents dust from forming.
How big is this machine?
Might be about the length of this table, maybe a little bit more, certainly taller.
How tall?
The one that I saw, I don't know if it's the same one that would be used, but I've seen them, they're about 8 feet tall, like the size of a container.
And the length of that table, let's say 15, 20 feet?
Then maybe, Judge, it might go 25 or 30 feet.
Right, 25
Yes.
or 30 feet. A lot of noise involved?
Certain amount of noise, for sure.
How much material is going to be brought into this facility on a weekly or daily basis, like as far as tonnage, truckloads?
Well, two answers to that. One is, what I do know is that whatever is brought in and the amounts that brought in are actually controlled by the DEC. So the applicant can't go beyond what the DEC permits in its regulations. Number two, I know that Mr. Seaman, who is the town's environmental expert, requested as part of the EIS that the applicant provide limits to what it would bring in, so that those limitations and the manner in which it would be done would be made known to the planning board. And so the applicant did agree to provide those limitations as requested by the town's environmental expert.
Do we know what those
I do
limitations are?
not know.
Is that would you know if that's per truck, or per load, or per day?
I remember specifically that it was by day, that they wanted to know that it would be that it would only be within certain hours on work days and not on weekends.
But it's determined how many times a day? Like, is there a limit on how many trucks per day?
That I do not know, but what I do know is this, Judge, is that that's certainly within the purview and certainly is what the planning board is going to impose. The reason we're here now is that when the zone change happened, the planning board said, we're very sorry, you're 9 years in, you're about to get your final hearing, and we can't move forward. You have to clarify this matter. You have to go to the Board of Appeals. But Judge, and also Mr. Porcher, to your point, those are limitations and conditions that the planning board will impose. And the planning board has made very clear that it's going to do so. And the applicant has said, and this, by the way, these are at public meetings. The applicant has said that there's no issue with that. The applicant has no particular usage or tonnage or amount to which it aspires. Whatever the planning board deems best is what the applicant will do.
Is this facility limited to just crushing concrete and asphalt?
Yes.
Nothing else is going to be
Nothing else.
recycled, crushed,
No.
stamped?
No, that the planning board made that clear, and no, but To be fair also to the applicant didn't seek that either. But the planning board did clarify that point.
And this is just material coming from jobs they are working on Long Island.
Correct.
You indicated that it's the similar use, there's a similar use right next door, so to speak. That's to the west, isn't that correct? We've all been there, by the way.
Yeah, the way I look at it is, because when you go out of the driveway, Suffolk Concrete is sort of essentially diagonally across the street. You can just walk right there.
Right. But on the other end, if that's, we'll say, to the west, to the east, it's all residential homes, isn't that correct?
No, there's only one residential home that's nearby.
Disagreed with you.
Can the audience please be quiet until they come up to the podium to speak? Thank you.
As I understand it, and by the way, just like you, I've been there, but what was established at prior meetings, particularly before the planning board, is that the property that is, there's only one residence that's actually adjacent, and most everything around the area is industrial in use, and the property that's residential is itself a non-conforming use.
My recollection, having been there, and I know the other members of the board have been there, you drive down a residential block and all of a sudden you see the other firm that's still there.
Well, I guess, Judge, it depends on the manner, the path you take, because what I would know is that you would go in off a middle road, then you sort of make that turn and you go around to Manor.
See,
And
I
then-
went straight down Middle Road, and it was on my right.
But on Middle Road, you're on that for just a very short distance. It's only, I mean, it's not far off of Middle Country Road. It's not far off of 25.
Just for the record, is Suffolk Concrete crushing concrete?
My understanding is, what I've seen is that there are a number of folks there who are crushing concrete. I mean, these uses are not really, how shall I say, well hidden.
I thought they just made concrete, but maybe they are crushing concrete. I don't know. But you had mentioned the surrounding properties in the neighborhood, the adjacent properties are more intense and more impactful than the proposed use here. You want to expand on that a little bit?
Sure. Well, you have Suffolk Concrete, which is making concrete, as you pointed out. It's a very intense activity. You also have a property that's, I guess if I'm picturing it or orienting myself, if I'm on Manor Road and I'm coming out of the driveway and then I go to the right, which is heading in the direction towards Suffolk Concrete, that there's a trucking and materials operation there that places a bunch of things. So there's dust, there's noise, there's truck activity, there's materials being moved. All of those things are happening. And it's happening not on a site that would be regulated and in conformance with town code as this one is. Because I said this would be the only site in the surrounding area that would be subject to codes as they exist now. All of the others are these pre-existing non-conforming uses that essentially nobody can do anything about it, even if they wanted to.
Does your client own other facilities that do this?
The client did own one facility in Westbury for many years, does not anymore, but operated a facility in Westbury for almost 30 years.
Where does he currently bring his concrete and asphalt?
What's that?
Where is he currently bringing this material?
As I understand it, he brings it to Island Park, which is some distance.
I have a couple of questions.
Yes, sir.
You know, you were talking about applications and things like that, and you said you were told to make an application to the ZBA. Who told you that?
What's that?
You said that you were told to make an application to the ZBA. Who told you to make the application to the ZBA, the planning department or who? Or did you make it on your own?
Well, let me say this. Obviously, I did the application on my own on behalf of the applicant. So it's the applicant's application. Nobody in the town is making the application.
Okay,
But to your point, Mr.
Planning
Chairman.
department had no input on that? Did they deny it or approve it or what?
Well, they really can't, but they're aware of this section 301-222B. Because really, in a situation like this, that would be the only way that someone who finds themselves in this circumstances could move forward. Because again, I have to note, because I think it's very significant, we're not talking about someone who just comes forward at the 11th hour or is seeking something that maybe somebody was unaware of. This was made after 10 years in the process, because after 9 years, the zone was changed, which is a fairly extraordinary circumstance.
You indicated that the prior use, the existing use, it still exists, I think, in your opening statements. Is that occupied now, that home?
I know there are people who are there at times, Judge. Is it occupied every moment of every day? No, it's not. But
When was the last time it was occupied?
that I don't know.
And by who?
But it's occupied by employees of the applicant. Really is more of just as, really more, Judge, I have to be very frank, of course, really more on a caretaker basis, because you don't want a home that's in an area like that to be subject to somebody who might squat in it or come in and damage it. So that's why.
Do they rent?
What's that?
Do they rent?
No.
Is there any rental agreement, anything, any bills, anything to show it's in use? Anybody here to demonstrate that they live here? They live there?
I mean, Judge, I can provide that as a follow-up, of course.
All right. But there's nobody here tonight. There's no bills?
No, sir.
And even your J, your Exhibit J, the most recent thing that's dated was 1981.
Well, and Judge, the reason I attached those is twofold. Number one, actually the application requires it. So that was part of the application. Second of all, just to show that it was a non-conforming use that existed for many years.
I mean, they demonstrate that, but they don't demonstrate there's anybody living there now.
Does the house act as also like an office for the business?
That's true too, or it would. Or there's another aspect of it, which is that the home could be removed. I mean, if that's something that ultimately, when this is, I'll say this, if and when the applicant could proceed, you'd be in a situation where, pursuant to 301-222B, you would move from one non-conforming use to another, at which point the home would not have to be there. So if planning staff or the planning department in conjunction with planning staff deemed that it was better for the site to not have the home on it, the home could easily be removed.
We're trying to also establish, is there an office in this house right now?
There are office materials there. Do people operate the office on an everyday basis? No. But remember, there's a reason for that too, because one of the things that the town has said is that we do not want a lot of activity in and out of this site until this matter is settled.
Is there like a phone line to the business that goes to that house?
No. They would use cell phones, as a lot of people do today.
What is the site currently used for?
Now?
It doesn't look like it's fallow.
Yeah, I mean, there's nothing that it can be used for now, because the town attorney has indicated it should not be used until these matters are resolved.
So it's not being used as a residence, it's not being used as anything at this point in time.
Well, as I told Judge Gazzillo, the residential aspect of it is still there, and people do stay there, because again, the property ultimately, the asset or the investment needs to be safeguarded, and also you do not want people who would squat or do something else in there.
So just for clarification, are you stating that the town attorney told you that the property couldn't be used as a single-family residence, or are you referring to the proposed concrete facility?
Well, Ms. Prudenti, that's interesting. I think that might be a bit of a hybrid, and maybe you and I could clarify that with Mr. Howard, but I do know this. It was made fairly clear that they did not want to see much activity coming in and out of this place because they thought that was going to be more respectful to the neighbors. So the applicant was very eager to accommodate what was requested.
So, have there been any violations or anything issued at this site?
There were violations that were issued about 9 years ago.
And that was DEC violations?
What's that?
DEC violations?
Yeah, those were cleared up almost instantaneously because the DEC's position was, you brought in some material, you didn't have all your permits in place yet from the town, so we need you to stop. That's number one. Number two, the DEC said, show us where the material came from, which they were very quickly able to do. Because the most important thing that goes on in the administration of what the DEC calls 360 permits, which relates to any type of material that comes into a site, is the origin of the material. But as I said, the applicant knows exactly where the materials are coming from because it's where they're working and they're not exporting in from out of state or anyplace else.
When did your clients purchase the property?
It was prior to 2017, the application. That for sure. Though I don't have a deed, so I don't know the exact date, but they owned it when they made the application in 2017.
And did your client obtain any permits or approvals for the use prior to the DEC violation from the town?
They had applied, but the approvals were not finalized.
Okay.
At which point then they stopped.
Was there a stop work order issued, Dan?
I'm sorry, Mr. Barnes, no, there was not.
That's okay.
No, I take that back. There was at first, and then everything stopped. But there wasn't a stop work order. The stop work order was not from the DEC. The stop work order was from, as I recall, the town.
The code enforcement.
Correct.
And the stop work order directed you to make application for a permit.
Actually, the stop work order was after the application. See, what happened was they jumped the gun. They had already
So they
made
were
their
clearing
application.
without site plan.
Yes. They had
Okay.
made their application, they jumped the gun, and they had to stop.
Okay.
Had they made their application to the DEC at that time?
Correct.
Had they made an application to the town at that time?
Yes.
We talked a lot about the site, when we mentioned the site plan. I think it's just important for the record. Did the planning board, did they ever actually approve the preliminary site plan?
No,
I don't think so.
no, they never did. As I said, it was unfortunate, but a matter like this, it's a very lengthy process. You have to go through a preliminary site plan. In a case like this, rightfully so, there's going to be a positive declaration. There has to be, because that's the only way that you're going to invoke in EIS a scoping process. Because if you don't do that, you're not going to have the level of scrutiny that you want. The applicant understood that, and that's where this very lengthy and collaborative process between town planning staff, Mr. Seaman, the town's environmental expert, and Nelson Pope and Voorhees, the environmental experts retained by the applicant, led to the EIS process moving forward. That took years. Now you can see in the document that I gave you, and I think, unfortunately, so I'll apologize, of course, that the only one that's tabbed is the one that Mr. Whitmire has. But these are documents H and I, and these are towards the end, and one shows that there was a scoping hearing, which only was set in February of 2020. That's 3 years after the application. And then you can see 3 years after that, which is in January of 2023, the planning board accepted the final submission. And then if you look at Mr. Dixon's letter, which follows the final resubmission, and you'll see the difference that it's marked final on the application paperwork. Mr. Dixon only indicates that there are 3 revisions left, and as I pointed out, they're really ministerial in scope. So these are folks who are about to be approved, and then the zone gets changed on them without their request or input, but we have to just accept and acknowledge that that happened.
Did planning board deny the preliminary site plan application?
No. It was just, the way that works, Ms. Prudenti, is that it just works through iterations until such time as planning staff reports to the planning board that it meets with their approval. And of course, ultimately, though, that is a decision of the planning board, but staff has great input in the process.
Right. But your answer is, it was never denied.
There was paperwork that came back that said the application process is denied at this point, which is sort of a formality in going forward so that the applicant is made to resubmit, when the applicant resubmitted here multiple times. So for instance, the applicant submitted in January of 2017. There was a staff report in 2018. There was an additional submission at the request of Mr. Murphy in March of 2019. There was secret scoping in 2020, and then a final submission in 2023. So the matter could not have been denied because it was always allowed to move forward with the revisions requested by way of comment letters.
So, you're stating there was no denial of preliminary site plan. When you submitted in 2023, that was for final site plan, correct?
Correct.
And the town code actually allowed for, even if there was a denial on preliminary, to file and move for final, correct?
That I don't know.
Okay.
I couldn't speak to that process. What I do know is this, is that at every juncture, through the various iterations, the applicant made the modifications and responded to the comments appropriately at every turn so that the application could move forward.
So, what was the last action by the planning board prior to the 2023 submission?
The last action of the planning board was, as I recall, to request an appearance at a work session to indicate that they wanted final revisions.
And when was that?
I don't know the date, but it was prior to.
Approximate year.
I would say, since that was in January of 2023 and those documents are before the board, it had to be towards the end of 2022.
And that was based on your submission for final site plan.
Correct.
I have no experience with this, but I can't imagine how crushing concrete is not a very noisy process. Do you agree?
I would, Judge.
And this is outdoors?
Yes. Although I would say this, Judge, that one of the things that planning staff had suggested, which certainly is a matter to which the applicant would be amenable, is that the planning staff asked, could it be considered that this be done in an indoor facility?
But it's not part of the plan right now.
But but again, we're here to talk about a use, the particulars of the use, everything that will go on that site, the structures, the conditions, the restrictions, that's for the planning board to impose. And so I would say this, Judge, that that's certainly something that the applicant would consider, as the applicant has always considered every suggestion made by planning staff.
With all respect, that's what we used to call an if bet.
Do they exist? Do concrete crushing facilities exist indoors?
Yeah, you could put up a building that would surround it.
Yeah, they do.
You certainly could. And remember also, Mr. Portia, that it's always within the purview of the planning board, before a final hearing is set, to indicate what conditions they want, including changes to the site plan, because that's happened on multiple instances here.
So the special exception criteria set forth in the code, Chapter 105, 8, C2A1 through A13. Can you go through those points for the zoning board and demonstrate that you can meet that criteria?
I could, when you go to 301, 222B, it refers you to 105 as sort of what authorizes you to then utilize 301, 222B. So I focused on the 301, 222B criteria.
Well, it specifically states, Town Code Chapter 105-8, under CA, which I referred, the Board of Appeals shall grant special exception and special permits only upon the making of the following determinations. And then it gives a list. The use will not prevent the orderly or reasonable use of adjacent properties or properties in the surrounding area, or impair the value thereof. I could go on, but it goes, the use will be in harmony and promote the general purposes and intent of Chapter 301.
Well, what I did do, Mr. Denti, I thought that what I did do, now, I don't have that enumerated before me. If I have a copy, I'd run through it with you. Of course, what I intended to do in more of a narrative fashion was address those items as part of what I set forth earlier, talking about the nature and character of the surrounding area and other uses.
I'm just reading forth the requirements and what the zoning board has to consider and providing you an opportunity to address them. I mean, it's not earlier you stated you're here for an interpretation. You're not here for an interpretation. Your application is directly for a special exception. And the code requires the zoning board to follow this criteria.
I agree. I think, if I can remember exactly what I said, if I misspoke, I'll apologize, but I think what I did say is that it's a special exception that in this instance acts in the nature of an interpretation. But I do not disagree that it's a special exception. That's what the application clearly states. And 301, 222B is a special exception process. So I concur.
If I could.
Yeah.
I just want to learn a little bit more about the site. So I think if I tallied it up correctly, it's about 26,000 cubic yards of material that's going to be sitting there. If I look at you have 4 different areas where there's laydown material, either processed or stuff that's waiting to be processed. That's about 260 10-yard dump trucks. somewhere in that neighborhood. So I'm just trying to get a feel for that. How close is the nearest residences?
The only residence that I know that is adjacent is the one that is trying to get direction. I refer to it as right or left. It's to the left of the property if you're coming out, which I guess would be north or northeast, as the case may be. That is the residence that I refer to, that is the non-conforming use. In other words, that's a residence that I was informed by planning staff at a prior hearing before the planning board that residence is a non-conforming use. That's the one, that's the only residence that is essentially close.
And is there any special provisions that are in the construction of the facility that are meant to dampen any vibrations, things along those lines? I'll tell you the reason why I'm asking this. When we had the former Gallo site taken over on Hubbard Avenue and they began crushing vehicles, I mean, there were, by Gershow, for quite some distance around, homes were experiencing vibrations from that crushing. And I'm thinking about even a machine that size, which given the amount you're going to be processing through there, I'm surprised it's only that size. That's an awful lot of material that would be going through there. What the likely impact, I haven't seen the environmental impact statement, so I don't know if this was addressed inside there, but what the likely impact is, both with dust, because at some point in time, I don't see how you kind of keep the dust down if you're wetting it down. It just seems like you turn into a slurry. But what the impact is on neighboring facilities, neighboring houses. Obviously, Suffolk Cement probably is not going to care too much about that, but a residential facility would be completely different.
Well, as I said, addressing part of this earlier, the techniques and actually the equipment that's put into place that reduces dust is fairly effective. I mean, most facilities at this point in time, you go to other jurisdictions, those facilities have them because they're imposed by the other jurisdictions, other municipalities pursuant to their respective codes. And it's much more of a mist. So to your point, you think that it might create this sort of this mud pile, but it doesn't do that. What it does is it dampens the dust. So I've always observed that to be effective, but I guess that's always to a matter of degree, right? I can't speak to that in any expert capacity.
Let me interrupt. That's the dust when they're crushing the concrete.
Correct.
But when the truck comes in and dumps it, don't you anticipate to be dust with that too?
Well, but what they do is a lot of facilities, when the trucks come in and out, they have these elevated sprinklers that hit the dust, that hit the trucks with mist as they come in and out. Again, the town has made very clear that ultimately the provisions and safeguards that the town will want will come out of the site plan approval, because as part and parcel of that, there has to be the adoption of the EIS. And so there's been great work that's been done on that over the course of many years. And the only thing I would just hearken back to again is that in this particular instance, the town exercises the control in that regard, because this has to be done pursuant to current code standards, which everybody else in the area doesn't have to adhere to, because they were pre-existing and non-conforming, and nobody can make them do it even if they wanted to.
Okay.
How many, I'm looking at a satellite view, but how many, I know earlier you said that there's one residential
Well,
house.
there's only one that's adjoining, that abuts.
Well, how many houses are we talking, like, we're talking, from what I can see, and I don't know if this is a perfect satellite image, but so you got across the street as well, but like, how many houses are surrounding this piece of property in total? Residential houses?
You mean fanning out?
Yeah. I know there's only one adjacent border to a
Right.
residential home, but like, next to that, it seems to be 3, 4, 5 homes, and then across the street, it seems to be, from what I can tell, a couple homes at least. Is that fair?
Yeah, I thought maybe total as you fan out, I always thought that there were 6 or 7. But I don't have, you would see that much better. I don't have that in front of me.
You know, I just wanted to address 301-222B, the non-conforming building and uses section. One of the sections that we're supposed to be abiding by, which is tough in this scenario, is let me make sure I cite the right section. C, I believe it's C4.
Are you referring to 301-222?
Yeah, the section
This was specifically under 301-222B.
is the section that reads that the use will be in harmony.
That's 105.
Well, that's
Which is the
105, I'm
criteria.
sorry. So that section says the use will be in harmony with and promote the general purpose and intent of Chapter 301. It goes on, I know we touched upon it, but it goes on to say that, I don't want to read the whole thing, but it says that the code describes, same as described, light industrial as processing and packaging of goods, of products from raw materials in which the goods produced are generally of high value and in relation to bulk, and which do not generate, and I think this is important, which do not generate offensive noise, vibration, glare, dust, smoke, gas, or other nuances. So I think that's directly on point with what we're talking about here and the nature of this facility. You want to comment a little bit about these things that seem to be concerning and right on point?
Well, remember that, and this is where the nuance comes in. The application seeks a non-conforming use. So to your point, this will not conform to light industrial because 9 years into their process, as they were awaiting their final hearing with the few minor revisions, the code was changed. But up until that point, it conformed to what was permitted in the Industrial A Code. So that's why, as I said at the very beginning, if we circle back, there's a reason why a provision like this would exist in the code, because not everything can be perfect, and sometimes the town board will take action, and that action may be very forward-thinking, or may attempt to enact a change globally, but somebody may be affected in a very inequitable manner. And that's what took place here.
So, is it your position that, based upon the argument of pre-existing non-conforming use, that the provisions regarding special exception set forth in 105 don't apply?
I'm not saying that they don't apply. I'm saying that they, although, it would not be for me to provide that interpretation in whole or in part. I'd have to leave that to you advising the board, but I would say this, that when you look at what those specifications are, if you will, including what Mr. Portia just mentioned, clearly they have been addressed by the circumstances that I've reflected, because remember, there are pre-existing uses here that are exactly the same. In one instance, you have a facility that's actually creating concrete, not just maybe breaking it down, but they're actually creating it. And as I said, but I'll just make it clear again, those facilities are not subject to current code, whereas this facility would be.
So, when you talk about your words, there's a pre-existing use here, similar to others, you would agree that the proposed project under the site plan is not a pre-existing non-conforming use.
But it would be, and that's how 301 222B works. You
But-
go from one that is a pre-existing non-conforming to another that then is non-conforming.
I know, but you're referring to it now, presently, as a pre-existing use, and I'm just confirming it's not a permitted or approved pre-existing non-conforming use. The goal is to gain that status through this special exception.
Correct, and just to be more clear, I'll put a finer point on it, and maybe that's because I'm changing tenses when I shouldn't, but I'm using that, and there are times that I'm speaking that way because I'm talking about what the use would be if it were allowed to move forward. Because right now, there is the non-conforming use. And what 301 222B says is that then you can have another non-conforming use. This would be a non-conforming use because under light industrial, it would not be conforming, whereas under industrial A, it would be.
And just to confirm, you stated earlier that it is your intention to submit proof of continuous use of the single-family residence as a single-family residence, correct?
That's what has to be established.
Yes, certainly to the extent that you would want that, and I know, of course, I can supplement the record, particularly with the chairman's approval. I'll be happy to do that.
You offered that. I'm
Yes, I'm
confirming.
happy to do it.
Yeah, and I think we need it. I agree, we need that information. Because you're hanging your hat on the residential part of the component. And we need to decide whether or not that's been in existence as a pre-existing non-conforming use as a residence. And I don't know if it's being used as a residence anymore, or hasn't been. So we would need to establish that in the record. So you'll be able to provide that, right, Dan?
Yes, sir.
Okay, good. Thank you.
And with the chairman's permission, I'll supplement the record and I'll address the correspondence to Ms. Prudenti.
Can I ask a few
Sure.
comments?
Go ahead.
So I'm going through your environmental statement, and under D2, project operations, does the proposed action include any excavation, mining, or dredging during construction operations or both? Parentheses, not including general site preparation, grading, or installation of utilities or foundations. And you checked yes. Can you describe what those actions, excavation, mining, dredging?
Right. Well, it's all encompassing, but when you look further and delve further into the application and the supplemental responses that were provided as part of the EIS, it relates to the crushing of the concrete. There is going to be no mining. That wouldn't even be permitted, quite frankly. But it's not going to be any mining. There'll be concrete crushing.
Well, I'm just referring to the specific question.
Yes.
That was completed.
Right. But it's sort of...
Is there going to be any
it covers a number of
excavation?
things.
Any excavation?
You mean excavation in the sense of digging up the land? No.
Okay. Any mining?
No.
Any dredging?
No.
But you answered yes to that question.
But it's going to be the concrete crushing. Well, Ms. Prudenti, I mean, the applicant clearly wanted to err on the side of caution because excavation is encompassed by excavating machines. So if you have concrete, right, that is brought into a site. So I'll give you an example. A truck comes in, truck passes under the sprinklers, then you get to the area where it's unloaded, right? And then the concrete unloaded has to go into the crushing machine. How do you accomplish that? You use an excavator. It's like a backhoe. So the applicant had to be precise and err on the side of caution in answering appropriately.
Next, under D2, under section 4, will there be on-site dewatering or processing of excavated materials? Answer no. Correct.
Right.
So when they talk about on-site dewatering, I think that's what ZBA member Zaweski was referring to. So in other words, during the crushing process, it's not watered down to dilute dust.
It's not what I understand. I understand dewatering is something different. I understand that as an extraction process.
Okay.
I can clarify, it's an extraction process when the groundwater table is high.
Thank you.
Next, in section D2C, will the proposed action use or create a new demand for water? Response, yes. Will the proposed action obtain water from an existing public supply? Yes. Did the applicant receive a water availability letter?
Not yet, because the applicant was finalizing the process before, of course, it got shut down, of determining whether a water line would run there or an existing well could be used. That was an integral part of the EIS process that the applicant's engineers, Nelson, Pope, and Voorhees, have been in the process of working on with Mr. Seaman.
Okay. Did the applicant ever request or receive a map and plan for the extension of public water to the site?
Did the applicant receive request a plan?
Did the applicant request or receive a map and plan related to the request for public water to the site?
That's something that I could best have Mr. Voorhees, Chick Voorhees of Nelson and Pope answer, because Mr. Voorhees was dealing with the Riverhead Water Authority and also with Mr. Seaman, and he was addressing the particulars
Okay.
of that topic.
Next, under section D, will the proposed action generate liquid waste? Yes. Total anticipated, 220 gallons per day. Can you describe what liquid waste would be generated?
I can't. I'll have Mr. Voorhees address that.
Okay.
I have to think that's from the use of the water to prevent dust.
Will the proposed action include or will it use on-site one or more sources of air emissions, including fuel? Answer, yes. Material transport vehicles, portable screening and crushing equipment powered by diesel-fired internal combustion engines. True?
Yes.
Will the air emission sources require a New York State air registration air facility permit? Answer, yes. Will the proposed action result in the release of air pollutants from open-air operations or processes such as quarry and landfill operations? Answer, yes.
Yes, there certainly will be emissions. There are going to be machines and trucks there.
Will the proposed action produce noise that will exceed existing ambient noise levels during construction operation, or both? Answer, yes. Will the proposed action remove existing natural barriers that could act as a light barrier or screen? Yes. And they're proposing tree clearing, correct?
On some of the site, but then I also know too that the planning board has said is there's going to be plantings and buffering.
I thought of something while Emery was talking. They're crushing the concrete, they're crushing the asphalt, they're stacking it up on the property. Are they selling it to contractors to use, or are they using it themselves in the putting down of new roads?
My understanding is that they're using it themselves because these are road contractors. They're not concrete wholesalers or even retailers for that matter. They're union road contractors. They employ only workers from Long Island who are members of the Building and Constructions Trades Council of Nassau and Suffolk counties. Majority of their workers reside in Suffolk County. Many members of the building trades, which is how we refer colloquially to the Building and Constructions Trade Council, live in the town of Riverhead in particular. So hardworking people, that's who they employ, and that's what this business does. They build roads.
Just to clarify, this is not a facility that's then going to be a for sale facility where people come there and load up and get crushed concrete.
No, it's not.
This is down there in Wheeling.
So, Mr. Squadro, I'm looking at the resolution of the planning board, resolution 2022-038. Whereas the planning board, in compliance with SECRA and issuance of a negative finding statement, must not approve the Breezy Hill Group 6 LLC asphalt and concrete crushing and screening facility site plan application. Now therefore, be it resolved, the planning board hereby denies approval of the Breezy Hill 6 LLC asphalt and concrete crushing facility preliminary site plan application.
I addressed that with you earlier. These are the procedures that the planning board follows, because if you look to the earlier part of that paragraph or sentence from which you just read, it talked about the SECRA aspect of it. They needed to come back and expand the SECRA, so this could not be done on a negative declaration basis. It had to be then done on an EIS basis. Look, we know that site plan or land use applications in general are going to proceed in one of three ways. There's a negative declaration issued, or there's a negative declaration issued, but the planning staff will require what's called an expanded EA, which stands for an expanded environmental assessment. Or there's a third path, and that is to say that an environmental impact statement must be issued. And that's why this couldn't go forward in the manner in which you've just indicated by virtue of that, because the applicant had to come back at planning's direction and then seek an environmental impact statement as part of the application. That was done. And that's how we get then to the final submission, which again is reflected in the letter, which is the second to last document that all of you have in your folders. That's in January of 2023, but for Mr. Whitmire, who has his tabbed, that's item or exhibit I.
I'm not trying to be difficult. I thought my question was straightforward, if there was a denial. And there was.
But
And
not of the application, because the application continued. And it continued until a final
I'm just,
submission, which
I just,
and it was then going to be put on for a final hearing.
I'm just gonna read from the resolution. I didn't write this resolution. I'm not counsel to the planning board. I'll just read it one more time. Resolved, the planning board hereby denies approval of the Breezy Hill Group 6 LLC asphalt and concrete crushing and screening facility preliminary site plan application.
And I think, Ms. Prudenti, I guess we could be talking about distinctions that do not have a difference, because all I'm saying is this. Clearly, the planning board took that action, and that was an action that was part of the path to get it to final approval. And it clearly was not denied because the application moved forward in full force and effect. So I understand what you're reading, and there's nothing inaccurate about what you're reading, but I just need to clarify this so that there isn't the suggestion that the application couldn't move forward, because it moved forward in all respects. That's all.
And I'll tell you. We need any more information.
Can I call the environmental expert? So, Ms. LaSquadro, the zoning board would like to call and requested Jeff Seaman appear at the meeting tonight for clarification regarding the secret issues.
And let me just say, I think that's a wonderful idea, because clearly there are many aspects of the application that relate to what was done in the EIS process. I'm not necessarily sure that they're particularly pertinent to the code interpretation, but I think it's important for the overall background of how we got to where we are. And to the extent that Mr. Seaman has things that he says that need to be answered or clarified by Mr. Voorhees from Nelson and Pope, then I'll make a note of that so I could have Mr. Voorhees supplement the record.
Well, I suspect a lot of those issues will be appropriate before the planning board.
Very good. May I? Thank you.
Thank you.
Thank you.
Wow. He's not- Seaman will have to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Jeffrey Seaman, Hampton Bays, New York. I am the environmental consultant to the town of Riverhead, and tonight representing the Zoning Board of Appeals in order to, I think, clarify and try to remap where we are under the secret process. But before I begin, I think I have, if you'll allow me, a few clarifications to some of the questions that were asked of Mr. LaSquadro. And please, I think you have to forgive both of us, since this application has restarted. I think the last time I was involved was sometime in 2023. My major responsibility throughout the process in what I will call Breezy Hill Part 1 dealt with the secret process, the procedures, and the review of the environmental impact statement, which may serve to answer several of the questions that were asked this evening, but I think for the benefit of the judge, if I may also refer to you as the judge.
Just don't call me anything else this one.
Well, I think one of the questions that was asked was what was the volume of material that could be permitted. Under the New York State DEC Part 360 requirements, which would regulate a C&D processing facility, the applicant had applied for a permit. There are two avenues. One is a permit, one is a registration. A registration would cover a smaller facility. A permit, which is what has been applied for, is for any facility that would accept and process 500 tons per day or greater. With respect to the throughput, the size of the machine, how much could be processed in any single day, yes, they do vary in size. Many of them are mobile. They can be transported from site to site. But the quantity with a daily throughput is specified in the EIS by a cut sheet for the particular machine that the applicant proposed to use. So that is a variable. So although you may be able to import 500 tons in a day, you may not be able to process that much depending on the size of the equipment. However, the EIS, and I want to be clear, I don't have the specific annual volume, but I think if you did 500 tons per day, 6 days a week, for an entire year, you would come up with a substantial number. But I believe during the environmental review process, that number was reduced. But that is in the previous EIS that was prepared for this application. I do agree with Ms. Prudente's comments regarding the denial of the preliminary site plan. And the way the process worked at that time with the planning board was, while the preliminary was denied, the applicant was instructed that they could prepare a final site plan and a supplemental environmental impact statement to support their final plan and give them a second bite of the apple, providing that was done within a 6-month period of time from the denial date, which I believe was April 21st, 2022. The applicant met that deadline. I think the submission was done in October. And that started again the environmental review process. Now, the conundrum that I see tonight is that once that process started, the planning board took the responsibility, as it had done in the original EIS, as being the lead agency. However, this application, which was filed in December of 2025 and brings us here tonight, was never a part of that environmental study and was never intended at the time the applicant resubmitted in 2022 in October to be a part of the environmental review. So much of what has been discussed tonight would not be included in the supplemental environmental impact statement because it was never part of the final scope. The final scope has been already issued and authorized by resolution by the planning board. Now, the problem I see is that because of the application before you tonight, by de facto, you are now an involved agency under SEQR. However, you have never been part of the coordinated review of the prior EIS, with the exception of your involvement on the interpretation, which, standing alone, is a type 2 action, as many of your applications are, so you have very little involvement in the secret process. So what I'm trying to do tonight is to come up with a recommendation which somehow has to find its way back to the planning board, that their actions, while appropriate several years ago under the requirements that they had given to the applicant for their submittal within that 6-month period, and the items identified at that time that were to be subject to greater scrutiny under a supplemental environmental impact statement excludes any of the dialogue or application processes that are before us today. So, under SEQR, in section 617.8, there is an avenue for comments on a draft scope that can be added to the final scope, providing there are substantive reasons why those comments weren't previously submitted and whether or not they would be significant to the application. And I think it's obvious that the Zoning Board of Appeals comments and the public's that you might hear tonight would be substantive with respect to the land use and zoning issues here. So what my recommendation would be, using that as an avenue, is to formally request that the planning board at the appropriate time perhaps rescind its adoption of the final scope. And if this hearing remains open, since you can't make any decisions until the secret process has been completed, allow a new resolution to establish the draft scope, give the public an opportunity, as well as this board, to submit additional comments to the original draft, and then issue a final scope. That would be my recommended option. The other option is the applicant would have to withdraw everything and resubmit from scratch. I think that would be unfair because I think, first of all, they would not meet the 6-month deadline that had been given to them previously by the planning board, and that would seem to be an excessive recourse. How that application and request to rescind and reestablish the scoping process with the planning board could take place either through direction of this board or request. It could be requested by the applicant. Again, not only because the involvement as an involved agency by ZBA on this matter, but also because the zoning has changed. And under the original application, the uses now contemplated under the light industrial were not part of that industrial land use and zoning issue that was previously studied. So much of that can be thrown out the window, and under 617.8, you could just supplement what's already out there, but I don't think that's the correct avenue to go, because you are now an involved agency, and I would imagine that the land use and zoning issue is a real core component of the EIS. And I think it would be appropriate, after you review tonight's hearing, that you may have even more questions or issues that you would like to have added into the EIS process.
So Jeff, if I could just summarize and be really direct on this, true?
Correct.
They declared themselves lead agency,
Yes, they
correct?
By resolution, yes.
Zoning board is unable to make a determination until the secret process is complete, correct?
As an involved agency, yes, correct, after the supplement, after the final
I'll be really
EISs, yes,
succinct. Ready?
correct.
It's your those are 2 points you've made. You've also recommended that the zoning board take the position not to request planning board have applicant renew the recent processes, but instead have the planning board, the request from ZBA, the recommendation would be to rescind the adoption of the final scope, include and list the zoning board as an involved agency, to permit the zoning board to submit comments prior to the completion of planning board's final review.
Correct,
Okay.
and to continue the coordinated review process with the ZBA.
I'm confident in the planning board processes will go according to the required secret process. My responsibility, obviously on behalf of the zoning board, is that the zoning board adhered to secret, lead agency status, no determination until completion, and obviously follow your recommendation.
Yes, and
Okay.
also to acknowledge that as an involved agency, the Zoning Board of Appeals, at the time the final supplemental impact statement is submitted, will render its own findings statement, which is independent of the planning board or any other involved agency's finding statement.
Thank you.
Thank you.
So, thank you for the public. Mr. Esquadro, do you want to respond, or can we let members of the public?
Maybe if I could just
Sure.
address one or two of those points?
All yours. Thank you, Mr. Seaman.
So, clearly I agree with much of what Mr. Seaman has said. We all know that he's very, very good at what he does. And I know our experts, particularly Mr. Voorhees and his team from Nelson Pope and Voorhees, worked with him on this over the course of years, and only with the best feedback possible. Just maybe to put a finer point on some of the clarification, because you sort of have the conundrum here. What comes first, the cart or the horse? Because we know in other instances you could have, in this town, but also in others, and we've come across instances where somebody comes forward, well, let's say with a change of zone. It's a town board matter. And the town board has indicated, maybe at a work session, that it's amenable to the use, and citing this on a particular parcel as is presented or as suggested. But that might require certain area variances that the town board can't waive, would have to go to the Board of Appeals. And so in those instances, a town board will refer the matter to the Board of Appeals, and then it comes back. But the town board is lead agency. But yet that hearing and the determination is able to go forward. And that doesn't prevent the matter from going forward. So in other words, the Board of Appeals can hear the application, normally it's understood that it's going to have to go back to the town board in the scenario I'm giving to you. And then the town board has to act. So I do hear what's being suggested. What I'm noting, though, is that you are an involved agency. Mr. Seaman is correct. And of course, we can all acknowledge that nobody could have anticipated this because nobody knew that after 9 years of an application that the town board was going to change the code and eliminate the use. So therefore, this application was necessitated by that. What I could suggest, however, and of course you'll have to make the determination that you deem best, but that is, your determination could still be made, but everything that's done here and all comments that you wish to convey, particularly on an environmental basis, would be conveyed to the planning board in any event. And the planning board can choose to redo the scope and rework the EIS to take into account things that are said here, to the extent that those things were not accounted for in everything that they did over the course of years. But again, I just think that
How long has the secret process gone on before the planning board?
at least 3 years, probably 4, because as we know, which I pointed out to you, there was one of the documents I provided. It's item H that Mr. Whitmire has. But of course, that's one of the latter documents that indicates that there was a February 20th, 2020 scoping hearing. But there's of course a lot of work that precedes a scoping hearing.
Exactly.
So we were going back to 2019.
And they've declared themselves lead agency twice. And they already commenced the second process. Right?
Yes.
Okay.
So I imagine what really I guess needs to be thought about is, how is this done to not prejudice what, the applicant acting in good faith and bringing this forward? It seems to me that Mr. Seaman was saying that the planning board would have to agree to reopen. And then the planning board would then, see, now, this becomes interesting. And this is where I say, which comes first, the cart or the horse? Because Mr. Seaman has suggested, and again, I don't disagree conceptually, but I'm also thinking practically, but Mr. Seaman has suggested that the planning board would reopen, reestablish the scope, move forward with the EIS process, and then there ultimately would be an adoption. And that adoption by the planning board would then allow you to make your determination here. But
No matter what, the planning board must complete that process. Agreed? So you keep talking about which comes first, the chicken or the egg. The reality, in this application process, planning board must complete their environmental review.
But they can only do that in conjunction with a vote on a final application. That's the process. I mean, so that's why I'm saying that there's your
Submitted the
conundrum.
final site plan to them.
Excuse me?
You submitted the request for final site plan approval to them.
Then I think what we would need is the assistance of the Office of the Town Attorney and the recommendation and even consent of this board, because the planning board would be of the position that they can't move forward until this issue is clarified here. But if you can work that so that can happen, then I think maybe there's your
I
solution.
respectfully disagree. The zoning board accepted your application without a denial, proceeded with the hearing tonight. They'll keep the hearing open. They've offered you an opportunity to provide additional submissions. I have other recommendations regarding perhaps other material you would want to submit. And if you do, I think the zoning board would grant you that, and they'll keep the hearing open.
And I wasn't referring to that. I think the board has handled this here tonight very deftly. I was actually speaking to the planning board. We'll need the planning board to agree to do what's being suggested. That's what we would need.
Right. And whether they do or they don't, the zoning board can maintain its position, to be perfectly clear. And aside from Mr. Seaman's comments, I'm sure you could appreciate I did my legal research on the secret process, the lead agency. So I think we're good.
Good.
Okay.
So the public's going to speak, and then if there are other documents or information you want to submit, you could identify it to us, and
Sure.
we'll agree.
And I'm sure Mr. Whitmire might agree to keep the hearing open for that purpose of submission.
We'll be kept
Thank you.
open.
All right, Mr. Seaman was speaking again, I believe.
Thank you. And again, I'm not trying to slow the process or make it more complicated, but it is complicated because of the timeframes that have been involved between the finding statement and the directions given by the planning board and now the involvement of ZBA under this application. What I'm trying to protect in the secret record, I don't want to see a split in the process and create a concern for segmentation of the review. I do understand that in some cases with less important land use and zoning issues, that might be an appropriate path to take, especially as was demonstrated in the interpretation process as a type 2. But this is a much larger issue. And what I would like the secret record to reflect is that all of the issues within the special exception request criteria are clearly discussed and outlined within the EIS. And we can't do that unless we get that information as part of the final scope, so that the applicant can't, in the final EIS, say, well, that was never really part of the scope, so we don't have to discuss it in great detail. So I'm trying to protect that entire record for the applicant and for both
Thank you.
boards. Thank you.
And Priya, want to do the...
Members of the public?
Before we open it up, can I read the written correspondence we received
Yes.
into the record? Thank you. So we received a letter from Claudette Bianco. We received a letter from Sally Donnellan. We received a letter from Amanda Louth. We received a letter from Group for the East End, and then also a letter from Barbara Blass. All of these were circulated to the board members and council.
Thank you.
All right, the public would like to speak. If you want to just come up to the mic, we'll swear you in. And if somebody talks about a subject that you're going to talk about, come up and say hello and then just pass. Don't repeat it, please. Oh, God, we're going to be friends. I'm going to get to know you. Excuse me. Please raise your right hand. I do solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Please state your name and address.
Hi, good evening. My name is Takri Turchin. I'm the Greater Calverton Civic Association.
Wait, can you just raise your voice
Oh,
up a
very
little
sorry.
bit?
I was afraid of the microphone. Takri Turchin, Greater Calverton Civic Association President. I'm here tonight representing most of the faces of the people that you see in this room. Yep. And those who are watching from home. And watching not only on Channel 22, but there were a few Zoomers on there. Once again, we find ourselves in front of you and listening for over, I don't know, what are we at, an hour and 45 now? We were just in front of you 2 weeks ago. These are the same neighbors. We recognize the importance of the development along Middle Road. It is incumbent upon us to make sure that we're knowledgeable and aware, and that's why we got ourselves out of our houses tonight to come down here and sit before you. I don't know that everyone's going to speak to you. Maybe that will be a blessing to you. But I would like to, I submitted a letter from the Civic. It's very brief. I'd like to read it to you into the record for the benefit of the record, the auditory record. So Greater Calverton Civic Association respectfully submits this written objection for inclusion in the official record concerning this appeal. The association represents residents of the Calverton community who are directly affected by land use decisions along Middle Road and surrounding industrial corridors. The submission objects to the requested special exception to convert an existing non-conforming single-family residential use into a solid waste management facility involving construction and demolition debris processing, including concrete and asphalt crushing and screening. The unlawful intensification of non-conforming use. Town Code 301222B permits the the Zoning Board of Appeals to approve a change from one non-conforming use to another only where the proposed use is no more detrimental to the neighborhood than the existing use. I take a pause here because what I heard tonight for the better part of an hour was a representative from the applicant mischaracterizing this neighborhood. It is in an environmental justice area, and there are industrial uses. But dating back to 1940, if you look at the aerials that were produced in their 900-plus page report, there was a residential house right at the corner of Manor and Middle, and it's been there ever since. Initially, the representative was splitting hairs over abutting versus adjacent, and I'm very happy to see the seriousness with which you asked them to define the neighborhood, and I think that we all got a better feel for it after you asked those questions. The single-family residential use is inherently low impact. The proposed solid waste processing operation introduces heavy truck traffic, outdoor stockpiling of construction debris, continuous mechanical operations, noise, vibration, dust, diesel emissions, and particulate matter. This represents a clear escalation in intensity and external impacts. The prior ZBA interpretations do not authorize this use. Prior ZBA determinations interpreting whether concrete crushing is prohibited were limited to textual interpretation and did not grant site-specific approval or evaluate neighborhood compatibility. Reliance on those interpretations is legally insufficient. Solid waste processing requires heightened security. The proposed use constitutes solid waste management and carries documented risks to air quality, groundwater, public health, and community character. Approval through a non-conforming use substitution without demonstrated equivalency of impacts exposes the town to legal and environmental risk. Failure to meet required legal standard. The applicant has not demonstrated through competent evidence that the proposed use will be no more detrimental than the existing residential use. The record lacks comparative analyses of traffic, noise, emissions, and operational intensity. The cumulative impact concerns are incremental approvals of high-intensity uses along Middle Road collectively erode community character and environmental safeguards. This application must be evaluated within that broader context. Our conclusion: for the foregoing reasons, the Greater Calverton Civic Association respectfully urges the Zoning Board of Appeals to deny the requested special exception. The proposed use constitutes an impermissible intensification of a non-conforming use and fails to meet the standards of Town Code 301222B, respectfully submitted. Thanks very much for your time. Please keep your shields up. We're looking forward to your answer.
Can I ask you a question?
Very sorry. Yes.
How many people figure here? About 60, 70?
In here? Yeah.
And
I think your
they're
seating hits us at around 60.
All, other than the attorney, they're all your colleagues or part of your association?
So residents, raise your hands. There you go.
Anybody not a resident? There being none? Oh, thank you.
Thank you very much.
And do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? State your name and your address, please.
My name is Jim Goraleski, 1776 Middle Road, Calverton. My wife and I own the property adjacent to the proposed project. Lifelong Riverhead residents, here for about 38 years. I heard so many things today that I could comment on, but I could go on for a long time about it. I don't want to bore everybody. I would like to say, and I don't want to overstep my bounds, I appreciate the turnout of the people in the area, okay, that have an interest in what might happen here. What I would like to say is that counselor for the applicant mentioned that, I guess, feels that it's sort of unfair that there was a zoning change while his application was still waiting to be determined on. It's certainly the job of the town and the zoning board, whoever else might be involved, to set zoning for the town, okay, which is in the best interest of the town and its residents. When we bought our house there, okay, that had all been agricultural property at one time, and there were some residences, as well as Suffolk Cement was down the road there too. And before we bought the property, the zoning was changed to some kind of industrial use, I guess, to allow Suffolk Cement. But it wasn't until recently that I realized that my house was a non-conforming use, as well as the 7 or 8 other houses that are in the neighborhood there. And there were additional other houses there when we moved in, but they're long gone at this point. So to say that, and because of all of the delays which I feel were caused by the applicant and his non-compliance or activities that were not permitted, that's the main cause of his delay in his application through the years here. And like he mentioned, COVID might have a part in that also. But from time to time, it is up to the town to review zoning in an area, especially an area like Calverton, which over the last 20, 30 years has changed quite a bit. I mean, we've got some major developments in the area now. So much so that recently I was handing out some flyers, driving around and putting them in people's mailboxes. The developments that I thought were 5, 10, 15 houses turned out to be 50, 60, 100 houses. So I didn't even realize how much of a change there was in my own neighborhood, honestly. But throughout this whole process, okay, the delays, I feel, were not so much the town's fault, but the applicant's fault. This thing from the beginning was like a bowl of jelly. You wiggle it, jiggle it, you hold it under the light or in the heat for a minute or so, and it starts melting. When they originally came onto that property, they cleared it on a holiday weekend, okay, when nobody could respond to it. When police were called, okay, and they spoke to the responding officer, people that were clearing, they put a lawyer on the phone. Now, I don't know if it was this gentleman here, but he told the police officer that they had all the permits in place and they were allowed to do what they were doing, and it got done that day or over that weekend because the town was closed. Nobody could respond, only the police officer. And he couldn't do anything about it because the lawyer told him it was all legal. Well, that continued for the first 3-4 years. There was always something going on a holiday weekend. At one point, they brought in thousands of yards of material and dumped it on the property to process in the future. They changed all the grades on the property, dug a tremendous trench to hopefully put these crushers down into this trench in an effort to keep noise down eventually. So everything that they did hurt themselves, okay? And I think what really hurt them more than anything is the fact they had no regard for the people that live in the area. And that all comes to this, okay? 60 people here showing up and sitting here for 2 hours to show their concern of what's going on. And it sounds as if this is going to continue to go on. Like the attorney said, maybe 9 years. I didn't even realize it was that long. I always thought it was 5 or 6. But I know I've been to numerous meetings. I don't understand all the legal jargon, but I can only speak to common sense. And at some point, somebody's got to make a decision. I don't begrudge the applicant being able to use the property for some purpose, okay? But there's got to be a transition from industrial, heavy industrial, okay, which the cement block is heavy industrial in my eyes, and residential. It can't just be heavy industrial right up to the residents. And one final thing I'll say.
Thank you very much, sir.
Can I just ask you a question?
One other thing.
Yeah.
When I was privy to some of the paperwork, which I don't even know what particular paperwork was, whether it's an engineering study, the CEQA, whatever, it's, all pages and pages and pages of material. But when I flipped to the final page of one study, and they mentioned that my home and my garage, my property, would serve as a buffer for the rest of the neighborhood. From the noise, the dust, the vibration, that was pretty much it for me. I could never go along with anything these people were going to do. And if you got questions for me, I'll leave it at that.
Forgive me if I'm wrong. I think you said you live in there 38 years. Is that correct? Year-round? You're not one of those snowbirds, are you? And where is your house in relationship to the property? Is it across the street from you, down the block?
I am east of the property, adjacent. Our property lines meet, okay?
So you're right next door, so to speak? Correct. Have you ever seen anybody live there?
When they were changing the grades on the property, okay, there was a guy that ran the machine, that, a big payloader. He stayed in the house for a time being.
How long ago was that?
Period.
How long?
That was like the first year.
How long ago?
If he says 9 years they owned the property, that was 8 years ago.
Okay.
And then there was another couple that lived in there for a short time, maybe 6 months.
How long ago was that?
Again, with 8.5 years.
And could you describe the neighborhood? You're like right next door to them. What about the surrounding area?
There's a fellow next door to me that has a single-family home. I think he rents also, and it has a little landscaping business. The next house was purchased within the last 5 years by a Spanish family. The next one from that, going east. I'm going east now. Okay, was another Spanish family that bought. And then there is one on the corner. That fellow's been there for a long term.
Now, going west where the other existing facility is that the only other, for lack of a better word, industrial facility in the neighborhood?
You mean the cement plants?
Yeah.
Suffolk Cement? Well, Suffolk Cement is actually across the street, okay, to the west.
Right, but my question is that the only industry or commercial structure there?
Basically, there's 2 cement companies, okay?
No, but they're together.
To the west, no.
Yeah.
No.
Yes,
Separate-
other than those 2,
separate
we'll call it one. There's no others?
No, there's nothing. I'm trying to think how to explain it to you. There's 2 separate transit mix companies, Suffolk Cement and then Sears, Ready Mix.
And they're due west of you, and they're together.
Correct.
Other than that, it's all residential?
Yes, in the little block.
Okay.
And there's a large vacant piece of property that runs all the way over to Applebee's on 58.
That's not a commercial property, obviously.
I don't know what it is anymore.
It's just a lot, you see.
It used to be farmland, okay, when I came there, so what it is now, I don't know.
Thank you.
Anyway.
More questions, sir.
Anyone else?
I got one more question for him, Howard. In the last year, have you seen anybody renting the house? How about in the last 2 years? How about in the last 3 years? Okay.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and address, please.
Nemeth, Calverton.
Hey, your last name is what?
Nemeth.
Okay.
I've lived here for about 20 years, and I walk or ride a bike nearly every single day. I go all the way down to Suffolk Cement. Suffolk Cement is in a low, it drops way down. So to come up to these smaller houses on the end of Middle, before the cement, you don't hear them because it's much lower. And also the winds and the way it runs, you barely hear the sound. I've ridden my bike or walked down there for 20 years. Never have I heard grinding, crushing, or anything like that. Yes, there are trucks. And yes, it's a cement factory. They make bricks, they make all kinds of blocks. Across to the next block, I don't know how many acres that is away, on the small end of Toomey, behind those places, there's another cement company that makes rings for septic tanks and cesspools. Okay, but that's pretty far away. I've still never heard them crushing anything. Across the street, or on, I don't know what direction it is, southern part of Middle, across from these homes, is the potential for that industrial factory or place, whatever it's going to be. These people are like a piece of bologna being squashed by 2 fat pieces of bread. They have no choice. What are you going to do with their lives? If this factory comes in, the crushing and the vibration and the noise, even if you put a building around it, because if you can go to Grumman, you talk to anybody who lives over at Timber Point, there's a factory across the street from Timber Point at the Grumman site, and it vibrates and leaves noise all the time. Now that's a long distance. That's not like your backyard. So for these poor people who have homes there, 30, 40 years, to say to them, you really don't matter anymore because I'm going to build a factory that's going to make me some money and I couldn't care less about you. Thank you.
Ma'am, Stephen. You lived here, you said 20 years?
20 years.
Right. And where's your home in relationship?
I'm on Middle Road, down just east of Deep Hole in the Windcrest East community.
So how far away is it from this
Is
property?
that a half a mile?
And
It's
you-
about a half.
And you walk by it or whatever?
I walk 3-4 miles a day.
She's a walker.
They all know me.
Every day.
Up Deep Hole, by the
Right,
way.
but you walk by there virtually every day. Have you ever seen anybody living there?
No, not for, I used to notice the place because they have a little wooden bridge they built over a little, I don't know if it's a man-made stream or pond, and then there was that nice big house in the back. I never noticed anything there, but I wasn't looking specifically at them.
But you never noticed anybody living there, any cars or anything like that?
I
To your
haven't-
recollection?
No, I have not.
Okay, thank you.
Anyone else? No one else? No one on streaming?
Does anyone on Zoom want to speak on this matter?
Raise your right hand.
Yes, sir.
Do solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Please state your name and address.
Yeah, it's Richard Romansky. I live in Windcrest East. 46 Golden Spruce, and I was a real estate broker for maybe 30 years. I was a justice of the peace in New Hampshire for probably 5 years. I do have a question. Are you Attorney Prudenti?
Yes.
Okay. I know they've been calling you Miss Prudenti, but
I serve as counsel to the zoning board.
very well. This is the first time I've been before the ZBA. I did come to the other meetings because I just hate to see what's going on in the area. The previous fella that owns the house right adjacent, as a broker, if he went to sell, he would have to do a disclosure that his property is being impacted by this proposed factory, basically. I think this project has whiskers on it. It's been around so long. The whole character of the area has changed. Route 58 has gotten so busy that people do the alternate and come on Manor Road to avoid the heavy traffic on 58. Middle Road used to go straight through, and for some reason they ended up blocking it off so that Suffolk Cement, I guess it is, can bring their trucks through. They did put a stop sign, so the trucks have to stop there, but these are big trucks, and can you trust them? The whole character of the area has changed to residential. And I believe these farms are going to be almost obsolete with the high-rise, I forgot what they call them, farms where they can grow indoors 24 hours a day, 365 days a year. And these farms, as people get older and the kids don't want to continue doing farming, that they're going to become residential. So that's why I said the whole character of the area, it just doesn't warrant putting this concrete demolition type thing in. Any questions?
Thank you very much.
Thank you. Yeah, sure.
Good evening.
I do solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help me
I do.
God. State your name and address.
My name is Catherine Wheeler. My address is 46 Nicholas Way, Calverton. Where I live is about a half mile from where this proposed crusher is going to be, might be. And it's really north of Manor Road. So it's the first residential street north of Manor Road. Right now, with the cement works on Manor and Middle and Toomey, tremendous amount of truck traffic all the time. There is ambient noise that comes from the cement factories, and I know it's them because it stops about 5:30 at night. I just also want to say that at the intersection of Manor and Middle, there is currently a sign that says heavy truck traffic. I would like to know what that sign will say if there's, 500 tons of concrete coming in? So that's what I have to say.
Thank you very much.
I believe he has a question for you.
No.
Solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
State your name and address.
My name is Mike Cuomo. I live in Foxwood Village on Middle Road.
Want to be quiet, please, so we can hear him?
Can you just repeat your name and address, please?
I'm sorry.
Can you just repeat your name and address? I
Michael
couldn't hear.
Cuomo, C-U-O-M-O, no relation. 1407 Middle Road. Just a quick question. I'm a little confused and I want to make sure the distinction is clear in my head. So I hear everyone talking about concrete and concrete dust and the environmental impact of that. But I read that the application says concrete and asphalt. And I may be wrong. I guess the environmental consultant can clear this up. There's a big difference between those two substances, and that asphalt may be much more toxic than concrete. Asphalt does contain petroleum products and so on. So I just want to be sure that you folks understand that distinction, and that when you do communicate with the planning board, that among your requests is to make sure that that distinction is mentioned, so that the environmental people can be looking at both of those substances when they make their decision. And that's basic. I just want to make sure that that's clear.
Thank you. You want to speak, sir?
Please.
Okay. Solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
State your name and address.
My name's Steve Cool. I live in Timber Park in Calverton, across from the Grumman property, Applicant.
Your last name?
Cool, believe it or not.
K-C-O-O-L?
K-U-H-L.
Thank you.
So my comments will be brief and maybe too simplistic, but I have to make the point. When my wife and I bought the house in Timber Park 39 years ago, Grumman was still in operation. And the F-14s and the A-6s would come back home after flying over the ocean. And they'd be moving pretty quick, and they'd be pretty loud. And I remember one time mowing the lawn, and this was the first day I ever saw an F-14 come home. He came back and he banked in to make his final approach on the airfield runway. And as I looked up, I could see the patches on the guy's arm. I mean, that's how close these jets were coming in. And, I remember saying, God, it's loud. I don't know if I can stand it here. And then I thought to myself, wait a minute, they were here first. Grumman was here first. You know what, Steve? Get used to it. That's what you bought into. I think that the applicant should keep that in mind, that, okay, Suffolk Cement was there, and the people that bought our homes around the area, we knew that. We knew that the cement plant was there. It wasn't really noisy, but we knew what it did, and we were buying into it. We were moving in anyway. What the applicant, I think, needs to keep in mind is that now it's extremely residential there. There are a lot of people living in the area. You want to move in with a industrial plant that's going to make a whole lot of noise and change the aspect of the area. I think that's something they need to keep in mind with their application. Part two, and I'll make this even briefer. I get to cross-country ski the other day with all that snow. I get to cross-country ski up and down Manor Road. And 3 bald eagles, 3 of them, were sitting on top of those power lines. 3 of them. That's a real nice thing to have in your residential area. I don't know how much the bald eagles are going to want to hang out when the concrete's getting broken up. But I thank you for your time.
Okay. Thank you. We got one more? 2 more?
I won't do the whole thing.
I don't.
I promise.
I swear her in for sure. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God? Please state your name and address.
My name is Barbara Blass, and I live in Jamesport. Thank you. I do have a lengthy statement, and I will not read it all, but I did submit it to the board earlier today, so you have that. But I did want to just pull out a couple of things that I think may be pertinent. The expressly prohibited use in the light industrial district, there's a difference between a expressly prohibited use and a non-conforming use. And the use that's being sought is expressly prohibited, and you'll see that in attachment 4B of the Riverhead Town Code. There is no provision in Riverhead's code that authorizes this board or any other board to substitute an expressly prohibited use for a non-conforming use. Just doesn't happen. And there were a couple of comments that were made about, it appeared as though the applicant's representative was saying the town board on its own motion just went ahead and changed willy-nilly this, our property. That can't be more inaccurate. This application is in direct conflict with a comprehensive plan. And ironically, if you read in the adopted EIS, the applicant's EIS, it actually confirms and acknowledges the importance of respecting a comprehensive plan. It says, the need for a specific type and or location of development is established by the public in concert with the applicable town entity and expressed in the form of recommendations in a planning document such as a town comprehensive plan. Our community, this community spoke loud and clear, and fortunately the town board listened and adopted an update to our comprehensive plan. The town implemented that plan's recommendation on the industrial zones and amended the zoning, which expressly prohibits this use. So it was not some, we don't like them, or we don't want this here, or there's already so many of these here. Well, we recognized that and we didn't want it anymore. The community said it doesn't belong here anymore. So I wanted to sort of emphasize that. I also wanted to say that the planning board's adopted findings were very specific, the negative finding statement, and it included this following statement: the action is inconsistent with social, economic, and other essential considerations from among other reasonable alternatives. The applicant has not verified nor demonstrated actions to avoid or minimize adverse environmental impacts to the maximum extent practicable. They went on to specifically talk about lighting. When, where, how much lighting will be provided, measures to prevent fugitive lighting. This is what they have to do in their supplemental, and it hasn't been written yet, although they were given directive back in 2023. Adopted a final scope. We have never seen the supplemental, but here's some of the other things they were asked to make sure was included in that document. An operations schedule. When will activities that generate impacts such as noise, dust, nuisance, and or truck traffic will or will not occur? You need to let us know. Noise. The applicant is to provide a description of mitigation measures that could further reduce the potential for noise impacts to the neighborhood due to the proposed facility's operation. And by the way, the estimated throughput is 86,130 cubic yards of material. Circling back to your charge in Chapter 105-8, I'm not going to read those criteria. You are aware of them, and I'm sure that the public is aware of them at this point, but it's very, very clear that it would be very difficult for this board to determine that this processing facility will not, that generates air pollution, noise, dust, vibrations, and traffic, will not impact the residential uses adjacent to and in the surrounding area and impact their value. What about the health and safety and comfort of the surrounding neighbors? Can they sit and open their windows or sit outside? I doubt it. And it's a good time to also mention that 3/4 of the site, 4.37 acres of that site to be exact, which was forested, will be cleared if this application gets approved. The aesthetic, economic, and ecological benefits of that mature woodland would be lost, as well as the buffering that it provides. So I know you cannot make a decision. seeker has to be concluded in order for that to happen, and I know it's going back to the planning board for all of those issues and then some to be addressed. But I do respectfully request that the hearing remain open, which I understand that you're going to do, and I'm fully confident that after reviewing all the pertinent information and testimony, this board will find that the requested special exception cannot meet the criteria set forth in section 105-8. Thank you very much for your time.
Solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Address and name, please?
Christopher Dorr, 112 Northwoods Road, Calverton. D-O-R-R, yep. I live on Northwoods Road, which is about a mile from where this is going to be. And while we were sitting here tonight, I got on my phone and looked what was the decibel level of a concrete crusher. And it's 120 decibels. It's the same as a jet taking off. All day long from 8 to 5. This will decimate the property values of anybody within at least a 5-mile radius of this facility, because all day long there'll be a sound equitable to a jet taking off. It's just going to destroy our property values. Thank you. Thank you.
Can I say that would be it? I really appreciate the turnout, really. It's good to see that so many people care for this town. I happen to love this town. I've been here since 1950, and I'm going to be here a while longer and whatever, but I am so glad that you all came tonight and that the people that spoke, we heard you. Thank you, and we'll do our job.
The meeting isn't closed yet, so if you could please exit quietly. Are we going to adjourn?
Okay.
Well, we got a minute. What do we got? Minutes to do?
Okay.
Let's adjourn.
We need to,
Well, we got to adjourn this.
Appeal 2025043, hearing shall be adjourned to a...
They're not going to be able to hear you because the speaker's picking everyone up.
You guys make up your mind.
You want me to read it? I can project.
Heather, ask for submissions within 30 days.
We got it. Project. Okay. All right. Members of the board, so for appeal number 2025-043, the hearing shall be adjourned to a future date for planning completion of SECRA and submission of the documents requested of the applicant this evening.
So moved.
Within 30
Second.
days.
Within 30 days.
So moved.
Mr. Barnes?
Aye.
Need a second.
Aye.
Aye.
And I vote aye, so we're adjourned. How about
Nope, don't run away yet.
minutes?
Minutes, January 8th, 2026.
I move to approve them.
Second.
All in favor? Aye.
Our next
Aye.
meeting date is February 12th, 2026. Motion to adjourn?
Yes.
So moved.
Second.
Second.
All in favor? Aye. Leroy,
Aye.
thank you.